Thank you. So my name's Steve Thompson, and I'm with Owen John, who's in a different room for social distancing purposes. And we're going to talk to you about various issues in relation to Brexit. Obviously, it's very, very hot at the moment, and nothing else on the radio. It's managed to and the telly managed to bump coronavirus off the top spot, which is quite something. So we are going to just chat through a few issues today. We probably won't keep you for more than about 40 minutes or so. Obviously, this is all subject to change depending on what actually happens with these negotiations. And what's interesting is that, I mean, I was preparing my slides and found that quite a few of the things that I've got to touch on are actually subject to negotiations at the moment. So obviously, this is a bit of a sort of a high level run through things for you, just so you'll have a few ideas about the kind of things you'll need to think about. Obviously, everything's subject to clarification when we get to the other side of the negotiations once the transition period ends. But so what I'm going to do is I'm going to endeavour now to put some slides up, because you can't have a talk without slides. So I'm going to share those. So hopefully everybody can see those. I can. So, and I'm going to start the slideshow from the beginning, which is always a good place to start. So, as I say, my name's Steve Thompson. Owen John is with me. We're both partners at Darwin Solicitors, which is a commercial law firm based in the centre of Cardiff. Owen is an employment specialist, and I'm more on the kind of corporate commercial. So Owen's going to talk later on about some employment-related issues, and I'm going to start off talking about some contractual issues. So just giving you the quick heads up there, these are the AGP slides, so the Accelerator Consortium created in 2015. I'm not going to read it all, but I'll just give you a second there just to read through to see what this is all about. And then this is basic introduction for you, which I think some of that's already been covered. So just getting into it. So just want to have an initial think to start with about contracts, because obviously if you're in a situation where you're contracting with foreign parties, so businesses in Europe, whether it's as customers or suppliers or what have you, then Brexit will have some sort of impact on that, but we don't know exactly what it's going to be yet. So there's really two angles to this. Is, well, what about your existing contracts? What do you do, and what should you be thinking about? And what about future contracts? So I'm going to kind of touch on both, and it's quite high level, this, as I say. I'm not going to get into the absolute minutiae, but it's just to give you some ideas about the kind of things to think about. And I've no doubt that the guidance that we'll get once we know what we're doing will be highly confusing. So it'll take a while for people to really work out what's going on. So just some initial thoughts there, what might be sort of potential pain points, as they say. So obviously tariffs, and I don't purport to be an expert on tariffs, but that's something to think about, because that may well have an impact on where we are with things. And then there's obviously going to be customs processes and procedures, and it's not just a question of, you know, who's going to do that and who's going to be responsible for the cost of all of that, but also that might result in delays. I mean, you know, there's plenty of businesses are coming onto the radio and the television talking about that got delays already because the ports aren't operating the way that they usually do. So quite apart from the effects of COVID, businesses are having trouble getting parts and supplies for what they do. And then we've got issues in relation to the movement of people, and Owen will touch on that a little bit later, and I'll just drop into it from time to time. And then there's things like exchange rates, which obviously we need to think about as well. So just thinking about contracts that you've got at the moment, and whether they're going to be subject to new rules and how that's going to affect those. I mean, one thing that has been talked about a lot actually during COVID has been force majeure clauses. And some of you may have come across these. These are normally buried at the back of the contracts, and nobody really bothers looking at these because they really relate to kind of, you know, civil strife, war, pandemics, that kind of thing. And obviously we don't have many of those, or at least we didn't. So they're kind of forgotten about, but everybody's been looking at those. A lot of people are dusting off their force majeure clauses because they've suddenly, as a result of COVID, found themselves in a contract that's no longer financially worthwhile for them. So people have already been looking at those from a COVID perspective, and they will potentially be looking at them in relation to a Brexit perspective as well, because you may find that because of the effects of Brexit, that a contract that you are currently a party to, that is going to go on beyond the end of the transition period, is no longer profitable or worthwhile you being a party to. So it may be that a suitably worded force majeure clause, if you've already got it, will help you with that. But I would say having spent a lot of time looking at these clauses over the last 12 months or last 8 months for COVID, it's probably unlikely that if you have a contract with a force majeure clause, that's going to help you if you want to get out of the contract because of Brexit or the effects of Brexit. But it's worth a look because you never know. So that's the first point. But as I said on that second bullet point there in the second section, it's unlikely that a standard force majeure clause will be triggered by Brexit. But who knows? It may be, if you've entered into the contract in the last 2 years, that some clever dick lawyer has put something in that basically means that you've got something that you can rely on. And also some contracts, the more detailed ones, have actually got provisions in which talk about government imposed changes. So it's always worth a look to see if there's any provisions in the contract that actually are triggered by government imposed changes, which is something that would result potentially from Brexit. And the other thing to think about as well is some of the more heavy duty contracts, and I'm talking the longer form contracts, sometimes have provisions in which deal with material adverse changes. So it may well be that you can argue, if something has happened as a result of the effects of Brexit, that there's been a material adverse change, and that will have an effect on the contract. So if you have a written contract, you will need to look at it. You'll need to think about, well, what's happened? What are the changes? And is there anything in there that will help me? And you can have a look for yourself, or you might want to get your friendly lawyer to have a look for you, just to sort of see if there's anything that will be to your advantage. Because there may be certain types of contract that actually don't really work anymore. So financial services and broadcasting contracts, because I think there's a lot of talk at the moment about how the kind of regulatory systems of the UK are treated by the European Union, because depending on how they are viewed, it may be that we haven't got sort of equivalent, so that our sort of standards in financial services are no longer deemed to be appropriate for the provision of financial services in the European Union. That's certainly something that's being talked about at the moment. And then the final point on that stage is all about frustration. And this is this legal concept whereby if it's no longer possible for parties to perform a contract, that basically they might be able to walk away from it. It's not something that happens very often, but you never know. It might be that as a result of some Brexit changes that your contract is effectively frustrated, which is a legal concept, which may mean that you can walk away from it. But you've got to be really careful about this kind of thing, because the last thing you want to do is write to the other party and say, oh, we think this contract's frustrated, therefore we're no longer performing. Because what you'll probably get back is a very nasty letter from a lawyer saying, oh, yes, you are. And if you don't, we're going to sue you. So you've got to be very careful about that kind of thing. And in relation to force majeure, just before I move on, that only arises if you have a contract which has a force majeure clause in it. It's not a common law thing. So if it's not in there, you won't be able to rely on it. So just thinking about doing, it's a fancy word, audit, but it basically just means just effectively having a look through it. So the first point there is the term of the contract. Is that going to remain in force when the transition period ends? So we're only really worried about existing contracts that will remain in force after the end of the transition period. So that's your first point, because if it comes to an end either before or the end of the transition period, which obviously isn't very long now, or shortly afterwards, it's not necessarily going to be a big issue for you. And it depends on the type of contract you've got. It may be a rolling renewal or for a longer period or what have you. And then the next thing to think about is flexibility, whether or not it is terminable on short notice. Some contracts do have no fault termination provisions. So if you are worried about a contract, you can have a look at the termination section, because it may be that what you can do is potentially give notice, a no fault termination notice, which would enable you to get out on a shortish period, say 3 months, something like that. So there may be some flexibility there for you if you're worried about it. The other thing to think about is whether there's any territorial references, so whether there's anything in there that is reference to the EU, because that might have an effect on what the position of the parties is under the contract. And also reference to EU institutions, law or regulatory references. I mean, I mentioned earlier on the sort of equivalency of our standards here and whether they're going to be accepted as part of any deal. So if there are provisions in the contract which relate to EU regulations, then obviously that will be something that will be relevant on the other side of the transition period. And obviously currency payments, I mean, that's always been an issue, but obviously there's going to be somebody bearing potentially more of the risk, depending on what currency contracts are operating under. And then tariffs as well. So obviously, if there's going to be tariffs, then who's going to pay for those? It's going to be an issue. And that's certainly going to be an issue for you going forward. Then customs clearance, I mentioned at the outset. So who's responsible for that? So you need to give that some thought. It may be that that's your that's something you have to bear or the other party has to bear. But that's certainly something you need to think about. And then finally on this slide, personnel travel between EU and UK, and as Owen will touch on the sort of the employment side. But if people are having to travel in and out of the EU to perform the contract, then obviously that is an issue to think about. So just a couple more points. Labour shortages, obviously, that's an issue, because if you're not going to have the kind of numbers of people anymore, because of the fact that you are using a lot of European Union people, then obviously that might be an issue for you. Data transfers, it could be a big issue, and I'll touch on this a bit later. This is all about data protection. Under the GDPR, that was basically the GDPR harmonised the data protection rules across Europe. So obviously, if we're no longer in Europe, then that's something we need to think about. I mean, there are provisions which should mean that things do work after the end of the transition period, but it's certainly something to think about. If you're transferring data in and out of the EU, then you do need to bear that in mind, more so than if you're not, basically. Again, financial hardship clause. Is there a clause in the contract? You might want to have a little look for that. I mentioned the force majeure provision, and also the material adverse change. Also, is there a change control process? So it may be that if you need to make changes to the contract, there may be, as I say, in the longer form contracts, sometimes they have a provision which enables you to actually manage a change process. So you might have a specific change control clause. So you might have to follow a certain process if you want to make a change to a contract. And I mean, typically, as I say, that's going to be in a much longer contract. The shorter, if you've got your standard pro forma terms, that's probably not going to be in there, but it's certainly worth a look. And also warranty clauses, you might need to think about what the effect of those is going to be in a kind of a brave new world. So that's just a few thoughts about existing contracts. And as I say, you'll need to have a look at them, and you have to think about it in light of what the rules are. A lot will depend really on the kind of practicalities of it, and how long the contracts are going to run for, what the value is, and what the sort of impact of the EU is on that. So looking forward then, thinking about future contracts, just got a few things here for you to think about as checklists. I mean, inevitably, if you've got a long, complicated contract, you will probably seek legal advice. And if you do, then chances are that your lawyer will be dealing with all of these for you. But it's always useful, I think, as a business person to understand the basics. So at the very least, you know what your lawyer is saying to you, and you can understand what they're saying to you. But ideally, you would be able to at least front end the process. So when you're negotiating a contract, because when we do a lot of training around contract negotiation for business people, and what we say to those people is that you need to understand the basics, so that when you get to your lawyer, when you've drafted your heads of terms, or you've got a first draft of something, it's at least there or thereabouts, because there's nothing more difficult when you want to get to a certain endpoint as if the starting point is way off. So we try and educate business people to kind of understand the key legal concepts. So when they're doing those early negotiations, they're kind of where they need to be, so that when they get to the lawyer, we haven't got to sort of have a massive diversion. Because if you're way off beam when you start the legal process, it's going to be much more painful, expensive to get to where you want to be. So after that mini lecture, first thing is parties, where the parties are located. Obviously, you may find in the future that if you've got options of suppliers, one's in the UK and one's outside the UK, and that all of the things are equal, you may decide to go within the UK just because it suits you. You haven't got to worry about the EU side of things. Then also, obviously, you've got to look at the definition of EU and UK to make sure that they are going to be correct in the brave new world. And again, I mentioned references to regulators and law. So if you are going to be signing a contract which has got provisions in that makes you subject to EU regulations and laws, then that's going to be something probably post end of transition period that you're going to be more wary of than you were before, because I think it was always accepted, obviously, that we were subject to EU laws previously. But as I said earlier, I mean, these are things that are currently up for discussion, and the UK sovereignty, and find out soon where that's going to lie. So it's just something to be aware of. Think about predictable events. Is there something that is potentially going to happen as a result of having a contract with somebody in the EU that you can cater for in the contract? So always think through when you're looking at a contract. Think, well, what are the things? I'm signing up for a contract for 3 years to do something, or supply something, or buy something. What things could potentially happen during that period? It's always worth giving that some thought, because you can build into the contract provisions to have a certain outcome then if certain things happen. And then in terms of supply of goods, those are the kind of things to think about, which I talked about already. And then services, I mentioned earlier, with sort of financial services, recognition of professional qualifications. So we'll have to see how that pans out, whether we've got sort of equivalency there. And then obviously exchange rates we talked about, data protection. Again, if you're transferring data into and out of the UK, so the EU, you'll need to give that some thought. And then think about termination. Again, it's always useful to have no fault termination provisions, but that cuts both ways though, because if you want to lock in a buyer, you're not really going to want them to be able to terminate that contract on 3 months. If you've got a 3-year deal with them, I mean, you do need to think about forward planning and make sure that you're not going to get locked into some crazy price structure. But equally, if you decide you want to build a 3-month no-fault termination provision, chances are that'll have to go both ways. So you may be giving a little bit away with that. And then just check through your disputes clauses and make sure that works. And tied in with that is governing law and jurisdiction. When we are advising clients here, because we're only qualified to advise in England and Wales, we always prefer, obviously, if we've got an England and Wales governing law jurisdiction clause, and that all the disputes are going to be dealt with in the kind of UK courts. But that might not be the case, and quite often there are foreign jurisdiction clauses. But I think particularly if when we're going to be out of the EU, it's probably even more reason that you would potentially want any disputes to be dealt with here. But equally, you might find that the other parties pushing back on that one as well. So that's a sort of a little list there of things to think about. So moving forward, I've got a few thoughts here on practical steps that you can take, and some of this is reflective of what I've said earlier, so there is a little bit of repetition. So just some sort of commercial issues first, just to think about in your business. Where are your top suppliers located? Or if all your top suppliers are in Europe, that might not be ideal, but then it might just be something you have to live with. Then think about shipping consignments. How much cross-border activities are going to be. That's something that you'll need to factor into your business arrangements, whether it's working out who's going to be responsible for dealing with that kind of thing, or cost of it. And then think about supply lines. So it's kind of the same point really, but thinking, well, which map it out. Where are they coming from? Because that's going to become more of an issue going forward. And that factors into lead-in times as well. So if you're used to doing things on a just-in-time basis, you might not be able to do that quite so easily, or at least not for a while, because there will undoubtedly be delays once we enter into next year at the ports. I've mentioned earlier, there's already problems. So if you're used to doing everything on that just-in-time basis, that might not work for you. So you might want to give some thought to how you do that. The other issue is EU funding. I think, to be fair, I imagine most businesses have been sort of, if they've been getting any funding over the last 12 months, it's been COVID funding. And I think everybody recognises that the EU funding is a thing of the past, and hopefully there will be something to replace it. But it depends on the particular industry sector. And then think about where your physical assets are. I mean, we've had clients who have, many years ago, actually, one particular client a few years ago, when all this came about, they actually set up a branch in Germany because they wanted to have an overseas operation, because they had clients overseas, and it was easier for them to have that overseas office that could service the requirements of those European clients. So they didn't have to worry about the fact that we were in the UK and the clients were over there. So, but that plays into the physical assets issue as well. Where do you want those assets? If you've got a lot of assets overseas, then you might not have quite as much control over them as you would like. And I mentioned earlier, having offices, warehouses and facilities, where are they located? It might be in your interest to have an overseas branch office. We do set up branch offices from clients from time to time. So just something to think about, really. And then just a few more commercial issues. That's where's the path of data flow around the world. So that's a GDPR issue. So you need to think about where your data is going. Cross-border trips, business trips by staff, that goes again to the issue of travel. So that's something to think about, how that's going to affect you. And also, is it going to work for you to have WTO trading terms? I think this is really one we can't really get into until we know exactly what's going to happen the other side of the current negotiations, and there'll be a lot more clarity then on what those trading terms are going to be. But I suspect that what we'll be doing here is rolling out more of these kind of things once we've got clarity on what the terms are, and you'll no doubt be bombarded with webinars and seminars to hopefully teach you and help you through the maze of new regulations and legislation. Think about core skills needed within the business, and also where they are, what workers bring those to you and where they're from. The issue then about EU workers, what proportion of your workers are EU and where are they? I mean, if you've got branch offices in the EU manned by EU workers, it's not necessarily an issue for you. But I mean, I think that, there's already many industry sectors that are finding that there's going to be an issue going forward if they do use a lot of EU staff. And again, as I say, what proportion of the core skills positions are held by EU workers in the business? It's another commercial issue to think about. And then think, what is the most valuable part of the business, and where is it? And I think you just need to have that process where you just sit down and go through that and work out, well, where's the value, and how is this all going to affect us? So just moving on now to a few legal risk assessment questions that you might want to think about when you're considering your position. So what are the legal jurisdictions the business operates in? So, is it all in the UK or is it some of it overseas? So that's something you need to think about. I imagine that most businesses by now have worked out that if they're operating in part of their business in Europe, that they need to give that special attention. But it's just something to be aware of. And then think about, I'll put these 2 points up together. So you've got two ideas. I might be winning the word count competition here for slides. So think about general legislation governing your business, and these kind of the point there about that will govern all businesses. So what general legislation applies to your business, and where does it arise from? So this is going to be a bit of a tricky issue, because if you're operating solely in the UK, it's sort of easier in a way, because you're generally just going to be subject to UK law. But if you're operating overseas and you're exporting, then you've got to think about what the rules are over there as well. And then you've got to think about industry specific or business specific laws. There might be, if you're in, something, the service sector, you will be subject to specific laws that govern what you do. And you'll need to think about, what's the basis of those laws. So if you're providing financial services into a country in Europe, then you are going to be governed by that country's laws. And once we come out of Europe, or rather after the end of the transition period, that's just something to think about. So I think it's just going to be a question of addressing your mind to, well, what are the legal ramifications of what we do and where we do it? And again, I think that's something that you're going to probably have to get your helpful lawyer to assist with. And again, you need to just think generally about the legal and practical implications on your business in terms of time and cost, because I mentioned earlier about the cost of dealing with importing issues, and there will be a time element to it. There might not be at the moment, but it will be more time consuming, and there will be a cost there, and you need to bear those things in mind. So a few more points on the legal side. Where the highest risk supply chains? I imagine by now, as I say, most businesses have probably thought this through and thought, well, we've got some supply chains coming into Europe, and there's a risk there that if we're, the other side of the transition period, that might be a problem for us. And the same goes for clients and customer contracts as well. So these are the kind of practical legal things that you need to think about when you're sort of going through that risk assessment process. And also just have a think about your standard terms of business, because these are quite often seldom looked at, and people just sort of, I mean, we get many clients who come to us who have got some terms that they either downloaded off the internet or got from ripped off from one of their competitors many years ago, and they haven't really ever looked at them, and they have a bit of a problem, and they suddenly find out that they're not fit for purpose. Now is as good a time as any to look at those and get them rewritten for you to make sure that they work for you, both from a kind of business perspective and also from the perspective of dealing with the outcome of the current negotiations. And think about clauses that might need negotiation in contracts, because when you're signing up a new contract with an overseas customer or supplier, most of the excitement is about the fact that you've won business. But what you need to think about is what you're actually agreeing to, because we do a lot of work with clients where we do quite high level contract reviews. So we will have a look at the contract and we'll concentrate on a number of areas, and they get the benefit of sort of knowing that they're not signing anything they shouldn't do. But all too often businesses just so excited about getting the work, they sign it and all they want to do is start the supply chain. But you need to think about that more now, particularly we're going to be in a, you know, out of Europe. You need to have a process where every time you have a new contract, particularly if you're in a larger organization where you've got salespeople who are just keen to get the ball rolling with the deal, that you do have a process for these things to be looked at. So if there's any negotiation to be done, that it's done properly. And something we do also a lot with clients is we put together what's called a playbook. So with contract negotiation, that they know by reference to their playbook, it's a bit of an American term, but it works quite well as a concept. You know those backstop positions that work for your business, and you know every time you're given a contract what they are. So your sales staff will know when they're negotiating terms, they'll know as far as they can go on certain issues. And if you have a playbook that you've put together and you've thought it through and it takes Brexit into account, that hopefully your people, your staff will not drop you in it when it comes to signing up new contracts. And again, think about termination, just to make sure that, you know, if as a result of Brexit contracts become in the long term unworkable, that you've got a way of getting out of them. So I'm just going to talk a little bit about intellectual property, not in any great depth, but just to give you a couple of ideas. So many IP rights will be affected by the changes, because a lot of the IP legal landscape is harmonized across EU. So if your business does rely on its IP rights to any significant extent, then if you've got patents or anything particularly registered, then that's something that you will need to think about, particularly if you're in the process of regularly registering IP. I imagine if you are, that you probably, or you'd have had advice from your patent attorneys or your lawyers or your trademark attorneys, but it's certainly something to think about. And different rights are affected in different ways. Confidentiality is unlikely to be affected. Confidentiality generally, I mean, there are certain sort of freestanding legal concepts, but most of the time confidentiality is dealt with in contracts. So, you know, everybody's heard of an NDA. That's how people typically preserve confidentiality at the start of a negotiation, or in a contract there'll be a confidentiality clause, but that's generally dealt with by way of contract. So the mere fact that we're coming out of Europe doesn't really necessarily affect that. Copyright, there are no registrable rights, certainly not in the UK. There are some EU directives, but certainly generally speaking, it's not something that people tend to worry about too much. Copyright tends to be one of these rights which people only get excited about, because you can't register anything in the UK. People only generally get excited about it if somebody else has infringed it. So if somebody's nicked your copyright, that you'll be asserting certain legal rights. So people don't tend to value that quite as much, I don't think, in business. We do say to clients that they should do an IP audit and they should get a handle on the value of IP in their business and work out where it is, what it is, and how to protect it. But certainly copyright is something that people don't generally put a lot of store by. Patents is a highly complicated area that I don't intend to get into today. But certainly if you have patents, there's previously not a lot of harmonization with the EU, but there have been some changes. So if you are in the habit of registering patents, or you are thinking of registering a patent, you'll definitely need to speak to a patent attorney, or a lawyer who specialises in the area, because the fact that we are coming out of EU at the end of transition period will have a bearing on that. And this next slide is my final slide, and I can confirm it breaks all the rules of slideshow preparation, because it's I put far too much text in there, and I was trying to trim it down a bit, but I thought I'll leave it in there because it might make some bedside reading for somebody, because we're quite happy to send the slides out afterwards to anybody who particularly wants to read them. Trademarks and designs, there are certain certainly with trademarks you can get EU registration, so that's going to change. So if you're about to register a trademark, it might be worth getting on with that. People generally don't register design rights as much. I mean, a lot of people register trademarks, quite a common thing to do, but design rights not so much. So if you are in the process of registering a trademark, then it might be worth getting on with that, because you might be better off doing that sooner rather than later. But as you'll see in that bulk of text there are going to be all sorts of provisions to deal with that. I mean, I think that intellectual property, my feeling with intellectual property and data is that they'd sort of been sorted out a while ago, unlike fishing. So there are provisional arrangements in place to deal with those. And also, if you've got a pending EU trademark application, that's something else you need to think about. But frankly, if you've got a pending EU trademark application, you're probably all over it anyway, and you've probably hopefully got a lawyer or a trademark attorney who can assist you with that. But that's just a sort of a high level view on that. Certainly, you will need to get some input. As I say, copyright not so much, confidential information not so much, but certainly anything that's registerable with European rights is something that you will probably need some guidance with. So I'm going to hand over to Owen now, and I'm going to operate the slides on his behalf. So it might not go quite as smoothly as you would like. So Owen's going to talk to you about some employment things.
Yeah, thanks, Steve. So as you mentioned, my name's Owen John. I'm an employment partner and lawyer here at Darwin Gray. I was kind of hoping that by now, when we scheduled this session, we would have quite a bit of clarity over employment rights and workers' rights and how it would interact with EU law going forward. I mean, unfortunately, it's a little bit of a state of flux at the moment. So I'm operating on the basis of kind of giving you an overview of the situation, plus a little bit of me rubbing my crystal ball and giving you some predictions. So I've got 3 slides for you, so quite simple slides. My first slide is kind of a little bit of a theory, which unfortunately I have to give you before I go on to the other bits. So this is the first slide. The second slide will be my crystal ball rubbing. So that'll be the hypothetical, how I think this will pan out and how I think Brexit will affect employment law rights. And the third slide is the more kind of specific takeaways for you. So things that immediately we know you can do to kind of prepare yourselves. But this wouldn't be a lawyer's presentation if I didn't give you the standard disclaimer at the start. This is all subject to change, deal or no deal. So please do bear that in mind, and it may well be worth us having another session in the new year when we have some clarity on lots of things. So as a basic sort of background of the theory of how EU law and UK employment law interact, Steve, if you want to bring up all these bullet points. Essentially, the way it works, that's it. Essentially, the way it works is that in a very simple way, and I'm sure lots of you will know about this, but in its very simplest form, the EU law sets a sort of a benchmark. And what it says is, look, all the member states, if you want to be a part of our club, then you've got to meet that benchmark. So of the currently 27 member states, previously 28 member states, of course, each has had to comply with that benchmark. And in theory, what Brexit does, depending on what sort of deal we get, if we get a deal at all, is it at least waters down, if not removes that benchmark. So the theory of employment law is that there will be greater freedom for a UK Parliament to legislate on employment law without having to meet that EU benchmark. Now, all UK political parties to date have said that Brexit is not going to water down workers' rights. But in the long term, it is very possible that there will be quite significant divergence from the EU benchmark when it comes to UK employment law. Now, but immediately nothing will change. So the European Union Withdrawal Act essentially creates this body called retained EU law, which is basically everything we've got at the moment. So the way it's been described is that as at 1 second to midnight on the 31st of December 2020, Boris Johnson will get a camera out and will take a snapshot of employment law in this country, and will then transfer that to sort of 1 second after midnight on the 1st of January 2021. So nothing will change immediately. All rights will be preserved. But then, and this is where it gets complicated with this deal, if there is no deal, for example, it sounds like Noel Edmonds here going on about deal or no deal, but if there's no deal, then essentially, with that benchmark removed, it's a decision for Parliament. Parliament can decide how it goes about legislating in employment law. But in terms of one of the three sticking points, as we understand it in negotiations at the moment, in terms of the one about the level playing field and state aid, that's where employment law rights come in. Because what the EU is basically saying is that, well, if you want tariff-free access to the single market, then you have to comply with our benchmark on workers' rights. And the UK, presumably, are saying back, well, no, the whole point of Brexit is that we want to legislate on our own terms. So that's why there's a little bit of guesswork and predictions on my part here. I mean, if you flip the slide, Steve, and I've brought up, so if you bring up all of those, and if you click again, because again, this wouldn't be a lawyer's presentation if there wasn't a little bit of, if you go back, if there wasn't a little bit of small print there. So if you look at the bottom right, I've sneakily put in there the words predictions only. What won't change are those areas of law that that involve the UK going much further than the EU benchmark. So, for example, maternity pay. So the EU benchmark on maternity pay is 14 weeks paid leave. Now, the UK offers 39 weeks paid leave. So in areas like that, we know that's not going to change. When it comes to number one there, the Equality Act, for example, the UK's legislation on race discrimination, disability discrimination predates any of the EU legislation on that and actually goes quite a bit further than it. So there are some areas that we know for sure won't change, but there are some areas that we predict will change. And I'm afraid I am predicting here because we don't know exactly where employment law will be at because of the way it's been kicked back and forth as part of that level playing field argument. But my predictions, and these are kind of widely held, are that number one, they're the Equality Act. What we think will happen is that there will be a cap introduced on compensation and discrimination claims. So at the moment, the EU benchmark is no threshold for compensation and discrimination claims. Deeply unpopular in the UK with the CBI, lots of lobbying bodies. We think that will go. We think there will be a cap introduced of probably around about 85,000, which is the unfair dismissal threshold, a cap on unfair dismissal compensation claims for discrimination claims. Rightly or wrongly, we think that's what will happen. The second one, working time directive. There is an EU benchmark that every member state must guarantee that workers do not work more than 48 hours a week. There has been one member state that has negotiated its own little opt-out from that requirement, and that was the UK. So the UK is the only country, the only member state, previous member state, who has said, we don't like that. We want an opt-out. And the way it's worked is that employers, lots of you might fall into this category, have asked your employees to sign a written waiver out of the cap of 48 hours a week. Deeply unpopular, waste of time, according to lots of lobbying bodies. And I imagine that requirement, the cap on 48 hours, will go. And therefore, the requirement for this little false waiver to be signed will go as well. Another prediction of mine on working time is when it comes to holiday pay, quite an unpopular in the UK, quite an unpopular case. from about 3 years ago now called the Bear Scotland case, which basically said that when people's hours and salary varies significantly, when you calculate their holiday pay should be calculated on the basis of all the hours they've worked, all the overtime, all the commission they've earned, for example. Really, really unpopular in the UK, unpopular with lots of my clients also. We expect that to go. We expect a clean slate on that. I think the government in the UK, with a bit of freedom on it, will say, wipe the slate clean. We're back to the rule where holiday pay is based on basic pay only. Rightly or wrongly, I think that's what will happen. Family-related leave and pay, we don't think this will change an awful lot, because actually a lot of, as I mentioned on maternity pay, for example, a lot of UK family-friendly leave and rights go much further than the EU benchmark. So, for example, shared parental leave is a UK concept that isn't benchmarked. So the EU don't legislate by saying that you have to have a shared parental leave arrangement. I mean, anecdotally, a lot of the Scandinavian countries are a million miles ahead of us when it comes to shared parental leave. But we don't think number 3 will change that much. But number 4 will, I think, 2P transfers. I'm not sure how familiar you are with 2P transfers, but in its simplest form, it's where either a business is sold or a service transfers from one entity to the other, and then all the staff who are assigned to that particular entity transfer as well. And with that, all their T's and C's are preserved. Incredibly unpopular in the UK in certain circles. CBI, I know, have been quite vocal about certain aspects of 2P. We don't think it'll be repealed, absolutely not. But in terms of the EU benchmark, the UK has always kind of scrambled to get there, and through gritted teeth. So I think, for example, the requirement for T's and C's to come over completely preserved will be watered down. I think employers in future in the UK will have a little bit of wriggle room to change T's and C's upon a 2P transfer. Also, the EU benchmark says that you've got to go through an informing and consulting process with staff who transfer, even if there's one transferring employee. And that's quite onerous, some would say, on employers, and I think that will go. I think that EU benchmark has been quite unpopular. I expect that to be brought into line with redundancy consultations, where you say, if 20 or more people are affected, then you consult for 30 days. But less than that, there is no set time period for consultation. Number 5, agency workers' rights. I won't go into any great detail on this because I've just seen the time, actually. Really unpopular, particularly the notion that once a temp has been with you for 12 weeks, they essentially obtain lots of the rights, such as rights to salary, as permanent full-time employees. So that is really unpopular generally in the UK, and I think that particular notion will go. And finally, I must disclaim once again, full of disclaimers, this talk, that I'm not an immigration lawyer. I'm an employment lawyer, so I can't give you advice on immigration matters. But insofar as I've already seen it affect a lot of my clients. Some of my clients who run care settings are really concerned about this, because lots of their workers are from EU countries. And as of the 1st of July 2021, there will be this requirement for proof of immigration status, and lots of them are concerned that some of their workers don't earn enough under the new points-based immigration system, where they've worked it out. Their workers would need to earn something like 26,000 a year in order to meet the threshold, but and some of them currently don't. So that's something to have on your radar, but it's also something to speak to an immigration specialist about. Do you want to flip the slide, Steve? So those are my kind of crystal ball predictions. I mean, more specific takeaways you can take. I've got 2 minutes. Do review staff contracts. I was looking at our templates that we use when we draft contracts for clients the other day, and they're littered with references to the EU and EU legislation, particularly when it comes to things like restrictive covenants and intellectual property clauses in employment contracts. Lots of settlement agreements as well contain lots of references to EU legislation. I don't think that will mean that on the 1st of January, those contracts are rendered worthless and unenforceable at all. But I think certain clauses might be rendered unenforceable. So it's important to review those contracts and to ensure that they are updated to reflect the arrangement post 1st of January. I appreciate it's an incredibly difficult situation because we don't know for certain what that will look like, which is a great frustration for you, I'm sure, but also for us. The same applies to review workplace policies and privacy notices, that whole exercise that you might have gone through a couple of years ago with the GDPR, with drafting privacy notices. Lots of those policies and privacy notices will make reference to EU pieces of legislation. So it's worth updating those and ensuring that those will be effective as of the 1st of January onwards. I won't go on to bullet point 3 because Steve has mentioned data transfers, but I mean, as things are currently, as of 10:15 on the whatever is the 9th of December, we're looking at the UK being described, I think, under the being recognised by the EU as a third country when it comes to data protection issues. Not a third world country, hopefully, but a third country, which kind of puts it in the same bracket as people like Gibraltar. So, from an employment law angle, I think there is an exercise to be done on data protection. If you are a business who transfers employee data in and out of EU countries, in and out of the UK rather, to EU countries. And the final 2 bullet points there, which I won't go into any detail at all, I haven't got the time. And also, once again, it's an immigration issue. But do take advice or at least consider this obligation on, it's not an obligation, but lots of my clients have actively taken it upon themselves to think, we have to support EU staff members in applying for settled status or pre-settled status. And finally, I think Steve has touched on this, but when you are traveling outside the UK into the EU and out of the EU, if your staff are doing that for business travel, then do consider the immigration implications of that. Again, it's more, those 2 bullet points are more immigration issues than they are employment issues. So that's my 2 pennies worth. I'm sorry I can't be more specific about things. I mean, it's a great frustration that we are still in a position where there is great uncertainty in employment law, but I hopefully I've given you a kind of a flavour of how I think things will pan out.
Thank you, Owen. So that's the end of our slides, and that's the final official slide, just so you've got it there. I'm going to stop sharing now. I don't know whether, Lisa, are you coming back on to...
Yeah, I'm here. Just to, you haven't got any questions on the chat facility there, but just got 2 minutes now. If anybody wants to come off, very lucky this morning, you've got 2 experts for the price of 1, which is more than we normally have on our webinars. But does anyone want to come off and ask either Steve or Owen a question now while they're on? No? I think you've given the information that they need.
We must have covered it really thoroughly.
You must be. It's all in the presentation there. Fabulous. Okay, as always, we can get the slides out to you as soon as we get your AG3s sent back to us signed, so keep a lookout for those, please. Thanks to Owen and Steve for giving their time up this morning. I know it's difficult trying to get all the information out when it's changing every day as well. It's not very helpful for you in that way either, but hopefully once it's all settled, we'll probably see you again in the new year with all the definite details there for everyone. So some of you I shall see on Friday at our Sales Techniques Masterclass, but for everyone else, thanks for joining us, and have a good Christmas and stay safe. So have a good one, everybody. Thank you.
Thank
Bye.
you.
Thanks.
Bye.
Bye.